Let's dive right into this explainer. We're going to break down a massive, ongoing story in the geopolitical and tech world, Taiwan's judicial investigation into the alleged diversion of restricted AI servers. Now, if you track global supply chains or semiconductor export controls, you already know the stakes here are absolutely huge. Our goal today is to cut through the noise and look strictly at the evidence. We're going to examine exactly what Taiwanese authorities have confirmed, what prosecutors are alleging, what the companies involved actually say, and crucially, what remains completely unknown. To do that, we'll follow a strict evidence-based roadmap. We'll start with the physical interception, track the judicial escalation, define the SHTSE controls, look at corporate responses versus staging theories, clarify a separate U.S. case, and finish with the unresolved evidence.
So, let's start at the very beginning with the physical interception from May 2026.
On May 20th, 2026, a coordinated law enforcement operation intercepted about 50 Supermicro AI servers at storage facilities in Keelung and Neihu. And these weren't your everyday servers. They were packed with restricted, high-end Nvidia chips, the ones with the advanced accelerators. Authorities grabbed this hardware right before its declared export. Interestingly, they also recovered roughly 9 million new Taiwan dollars in cash sitting right there at the scene. Finding millions in hard currency alongside highly restricted computing hardware really underscores the massive financial stakes we're talking about here. This physical seizure led to the immediate detention of 3 logistic suspects, and it really anchors the baseline reality for this entire investigation.
From there, things escalated pretty rapidly. Let's look at the 3 main enforcement waves.
What started as a straightforward physical interception of hardware at a port facility blew up fast. The investigation moved quickly up the supply chain, transforming from a logistics bust into a sprawling probe that targeted high-ranking corporate personnel across several major tech and infrastructure firms by late July.
The enforcement really played out in 3 distinct waves. After that initial May 20th seizure, Wave 2 hit on June 29th. The Keelung District Prosecutor's Office directed searches across a dozen different locations. This included the Taiwan branch of server manufacturer Supermicro, a local authorized distributor called Albatron Technology, and a data center operator named Chief Telecom. Following those searches, a court approved the incommunicado detention of an Albatron executive and 2 Supermicro employees. Then, Wave 3 hit on July 24th, resulting in the detention of a former Nvidia senior business development manager. So by the end of July, 7 individuals had been detained incommunicado by court order. Now, it's vital to remember that detention is just an investigative process to prevent flight or collusion. It is absolutely not a conviction. Everyone involved is legally presumed innocent.
To understand what prosecutors are actually investigating, we need to look at the legal framework. The core of this case revolves around Taiwan's Strategic High-Tech Commodities, or SHTC, regulations. Under Taiwan's Foreign Trade Act, AI servers equipped with advanced computing chips, like these high-end Nvidia GPUs, are classified as SHTC. Because these specific technologies are critical for developing advanced AI models used by geopolitical rivals, the Ministry of Economic Affairs demands stringent export licenses before they can be shipped to restricted regions, which includes China, Hong Kong, and Macau. That is exactly why this local enforcement action matters on a global scale. The Keelung District Prosecutor's Office is utilizing the criminal code for document forgery and breach of trust. Essentially, prosecutors allege that the suspects deliberately falsified customs declarations, falsely listing Japan as the final destination for these restricted servers. By plotting this fake route on paper, they allegedly tried to bypass mandatory SHTC licensing reviews with the ultimate intent of transshipping the hardware to Hong Kong and China. On top of that, prosecutors allege the corporate insiders involved breached their fiduciary duties to their own employers just to facilitate this operation. Why take the risk? Well, it all comes down to a massive performance gap. Restricted chips, like the B300 and GB300, offer astronomical output gains for AI inference compared to the export-compliant variants. Because restricted markets desperately want this computing power, a wildly lucrative BREC market is born. Estimates suggest a staggering 300% markup for diverted servers. That massive financial incentive is the alleged engine driving the evasion of these strict export controls. Let's move on to how the companies are responding and why we have to separate that from unverified claims. In complex supply chain investigations, it is absolutely essential to separate corporate acknowledgments from media reporting. Supermicro confirmed its employees were questioned and placed on administrative leave. And they stressed a zero-tolerance policy for illegal violations. Crucially, Supermicro stated authorities confirmed the company itself is not a target of the investigation. Albatron Technology confirmed through regulatory filings that its general manager was detained, but stated the company itself does not engage in server chip trading. Chief Telecom confirmed the search of its premises, but strongly denied any institutional complicity, pointing out that it operates strictly as a co-location data center with no jurisdiction over client hardware. We're seeing a really clear distinction drawn between the alleged actions of individual employees and the institutional responsibility of the corporations. Conversely, local investigative outlets have published some low-confidence theories about the network's internal mechanics, calling it a legal order, fake use, real resale model. And we need to approach this reporting with high caution. These media reports cite unnamed sources to claim the network operated for 3 years and pulled in nearly 10 billion new Taiwan dollars in revenue. The most notable claim is that suspects temporarily staged hardware at Chief Telecom's data centers to simulate domestic use. The theory goes that this would fool the mandatory Know Your Customer or KYC audits required by manufacturers, and once they passed, the hardware was supposedly dismantled and exported. It is crucial to underscore that prosecutors have not publicly confirmed these specific staging mechanisms, nor have they confirmed those staggering revenue estimates. Until formal indictments drop, these remain low-confidence, unverified allegations. This brings us to a vital analytical distinction regarding a completely separate regulatory action in the United States. Because multiple cases involve Supermicro hardware and regional actors, they get conflated all the time, but they must be strictly separated. On one side, you have the ongoing Taiwan case from May to July 2026, driven by Keelung district prosecutors, focusing on 50 seized servers, local logistics, and corporate insiders. On the other side is a March 2026 U.S. Department of Justice federal indictment against a Supermicro co-founder and others. That U.S. indictment alleges a Southeast Asian company purchased roughly $2.5 billion in servers, with at least $510 million allegedly diverted to China. While they both reflect a broad regional pattern of regulatory pressure, there is absolutely no official record establishing a direct operational or financial link between these two distinct cases. As we wrap up this explainer, we have to acknowledge the limits of public knowledge. A truly objective analysis means admitting what we just don't know right now. Yes, 50 servers were intercepted, but the exact historical volume of hardware diverted prior to May 2026? Completely unknown. Public prosecutorial documents haven't named specific recipient entities or end users inside China, or the ultimate destinations of any successful shipments that might have slipped through earlier. The line between individual legal liability and broader corporate compliance failures won't be settled until a trial actually happens. And any factual link to that U.S. indictment remains entirely unproven. These are massive questions pending formal indictments. Ultimately, this investigation exposes the deep vulnerabilities and enforcement difficulties within our globalized technology supply chains. Think about it. Legitimate commercial systems, logistics networks, data centers, authorized distributors. They are all under immense pressure from actors lured by these massive black market markups. If standard corporate compliance can allegedly be bypassed by simply staging hardware in a local data center, you have to ask yourself, how many other restricted technologies have already slipped through the cracks? The future of international export control enforcement depends on the answers to these questions. Thanks so much for joining this explainer. We'll see you next time.